Hi there, this is Jonathan Ginsberg, and I'd like to talk to you today about what you should do if you discover you left a creditor off your bankruptcy petition. Kind of that sickening feeling you're looking at your paperwork, or if the phone rings or a letter comes in the mail and you realize, oh my gosh, I left off this $5,000 debt, this credit card, whatever it may be. And that does happen. And again, even though we do our best to get credit reports, to collect copies of bills, it just sometimes happens. Things slip through the cracks and nothing you can really do about it after it's filed. So really the next step is let's fix the problem. And the good news is it can be fixed. If you leave somebody off, you can file a motion, your attorney can file a motion to add a creditor. All we have to do is prepare a very brief motion, send that creditor, file the motion in court, send a copy of the notice, the motion to that creditor along with copies of all the forms the trustee or the clerk of court has issued in the case to date, and it's as if that creditor was part of the original filing, so that's really not a problem. It becomes a little more problematic if the case has been discharged. So it's important if you are going to find, if you think there's any possibility you left something off, the sooner the better. Once the case has been discharged and the case closed, you really can't add it because, again, the case is over. In a Chapter 7 case, there's actually some case law in the 11th Circuit, which is where we're at. Georgia's in the 11th Circuit, 11th Federal Circuit, that says that an unlisted creditor is still subject to the bankruptcy even if that creditor, again, was not given notice. This is an unsecured creditor like a credit card. If the case was a no-asset case, meaning if there was no money distributed to other creditors, this unlisted creditor is going to be treated the same way, because the logic being he wouldn't have gotten anything anyway if we listed him, so the fact we didn't list him, he's really not harmed any. Now, a secured creditor is a little different story. That would be a car, furniture, something like that. In that case, I would take the position that the underlying debt, the claim that that creditor has on the property, survives the bankruptcy. I think that the personal liability you may have is extinguished. So what that means, let's just say with a car, if you didn't list a car and the bankruptcy goes through either Chapter 7 or Chapter 13, and the creditor realizes, hey, I never got paid, nothing ever happened, I didn't get notice, I think the creditor could come repossess the car, but I don't think the creditor could come after you for any personal deficiency money. So obviously it's better if you include everybody the first time around. Doesn't always happen, no reason to beat yourself up over it, but certainly let your attorney know as soon as possible when you realize that you maybe left somebody off. Even if you're not sure, it's better to put creditors on even if you're not sure, because if you really don't owe them any money, no harm, no foul. If you do owe them money, you've got it to list it. So, but that's what you do. It's a simple motion. There's a filing fee. I think it's $24. I typically charge $20, $30, a total $50 total typically to add creditors. I may add 2 or 3 for that. So it's a pretty straightforward process, but it's something you need to do if, in fact, you left somebody off. So that's what you do with missing creditors. Hope this has been helpful, and talk to you soon.